Hi everyone, in this and the next video we're going to be talking about fact sheets which have been produced by the government. So this follows on from the initial announcement about the Employment Rights Bill. The Department for Business and Trade have now, on the 18th of October, published 10 fact sheets about the bill and various changes that they're wanting to make. I've picked out some components of these fact sheets that are not necessarily explicitly contained in the initial announcement or indeed the legislation, and that might give us some insight as to what precisely is to come in the future. So there's an overview document first of all. This explains that further detail on many policies in the bill will be provided through regulations after royal assent. We expect to begin consulting on the majority of these reforms in 2025, seeking significant input from all stakeholders. For some areas we'll be consulting before the end of the year, including on applying the 0 hours measures to agency workers, modernising trade union legislation and statutory sick pay. So importantly there, no immediate changes are going to be made to legislation. There is some acceleration in certain areas, but we're going to be well into 2025 and indeed probably 2026 before anything comes in, because the overview document then says we will ensure businesses have time to prepare for the implementation of these reforms and expect that most will take effect no earlier than 2026. Where more time is needed for businesses to prepare, this will be taken into consideration. So possibly even later than 2026, which is some relief to many businesses. So the first individual fact sheet we're going to focus on is on 0 hours contracts. So the proposal is to require employers to provide a guaranteed hours contract in the event that a 0 or low hours worker works a particular pattern or a particular number of hours over a reference period. The purpose of the measures as contained in the fact sheet are to drive up standards and eliminate undercutting. So in this note I've picked out that employers will have to offer qualifying workers guaranteed hours reflecting the hours worked during the reference period. That is to be set out in the regulations, but the proposal is 12 weeks. So this largely mirrors the agency worker regulations, where an individual who has worked for an employer for 12 weeks then has the right to equal treatment with a permanent employee. The government's publishing a consultation soon on the application of 0 hours workers, 0 hours proposals to agency workers, so that the bill provisions are appropriately applied to this group. So quite explicit in stating that this is not just an employee situation, it's going to apply to temporary agency workers as well. The fact sheet says if an employer schedules shifts or changes with unreasonable notice, the worker can bring a tribunal claim. Regulations will state how much notice should be presumed reasonable, and this will be the tribunal's starting point. And detailed information regarding the right to payment for shifts cancelled, curtailed or moved at short notice will be set out in the regulations, including which contracts are in scope, what constitutes short notice, how much the payment will be, and any exemptions. So the intention is to create a sort of fixed compensatory regime in the event that there are changes to the 0 hours worker to their detriment. Maybe incredibly scientific, as we've seen with things in the past, like calculating furlough pay, for example. We'll move on to the fact sheet on unfair dismissal, so the juicy one for most businesses, and the removal of the 2-year qualifying period for unfair dismissal. The fact sheet confirms a statutory probationary period will be introduced to ensure employers retain the ability to ensure that the job is a good fit for both the employee and employer. The government proposes this period lasts for an initial 9 months of employment. During this period, a lighter touch and less onerous process will apply, and the 2-year qualifying period for a right to receive written reasons for dismissal will also be repealed. The fact sheet states that the government will now consult on the reforms, and interestingly says this will include the length of the statutory probation period and how the lighter touch dismissal process will operate. So the period has been suggested at 9 months. I'm going to stick my neck out and say I think this will increase to 12 months. I think that's just a concession the government are willing to make, and that's why quite an odd 9-month period of time has been suggested initially, probably to give a concession to employers. Interestingly, the government will also consult on the unfair dismissal compensatory regime for dismissals, and reforms will take effect no sooner than autumn 2026. The unfair dismissal regime is interesting. At the moment, we have a basic award akin to a redundancy payment and a compensatory award with a cap, either of a fixed amount or 12 months of earnings, whichever is lower. Not sure how that could be amended, but that will form part of the consultation as well. And the fact sheet finally says that the employer will be able to retain the ability to run separate contractual probationary periods of any length they choose. And that's really in relation to non-statutory entitlements. So, for example, employers will not be prevented from restricting access to enhanced company sick pay or life assurance, private health, subject to their own contractual probationary periods, but that will not affect the qualifying service for unfair dismissal. So in the next video, we'll move on to the other fact sheets, trade unions in particular, the Fair Work Agency and the fire and rehire provisions, which really do concern me. If you need anything else on these potential changes or anything employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.